Welcome back to Artificially Informed, the podcast series that offers an in-depth look at the Florida Attorney General's Government in the Sunshine Manual, 2025 edition. I'm Joel Chandler, and as always, this episode is produced with the extensive use of artificial intelligence. I write the prompts and review and edit all of the output. In today's episode 15, we're continuing our deep dive into Part 2, Public Records, specifically C, What Records Are Covered. Application of the Public Records Act 2. We'll be navigating pages 115 through 127 of your manual. Our discussion will continue our focus on law enforcement records, Section 15, covering everything from geolocation information and juvenile offender records to motor vehicle records, and a detailed look at victim information as outlined in your manual. Given the extensive detail, this episode will be significantly longer than our usual 15 minutes. Let's pick up right where we left off in the complex world of law enforcement records. Segment 1, C, What Records Are Covered? Law enforcement records, geolocation information, and juvenile offender records, pages 115 to 117. Starting on page 115, we continue our discussion of law enforcement records. First, J geolocation information, 15.J, on page 115. This refers to data that pinpoints a person's physical location, often collected through cell phones, GPS devices, or vehicle tracking systems. Law enforcement agencies might use this for investigations. Generally, specific geolocation information that identifies an individual's past or real-time movements is considered confidential and exempt from public disclosure. This is because it's highly personal and can easily be misused to track or harass individuals. The law balances the investigative utility of such data with the strong privacy interests of individuals. Next, still on page 115, we have K juvenile offender records, 15K. These are records related to minors who are accused of or found to have committed delinquent acts. The law treats juvenile records differently than adult criminal records due to the focus on rehabilitation rather than punishment, and the strong public policy interest in protecting the privacy of minors. First, 1. Confidentiality and authorized disclosure, 15K1, on page 115, sets the general rule. Juvenile offender records are typically confidential and exempt from public inspection. Disclosure is severely restricted and only allowed to specific individuals or entities, such as the juvenile's parents or guardians, their attorney, certain school officials, or other criminal justice agencies for official purposes. This confidentiality aims to give the juvenile a chance at rehabilitation without their past mistakes permanently following them into adulthood. However, the manual then details 2 exceptions to confidentiality, 15.K.2, on page 116. These exceptions outline specific circumstances where juvenile records or certain information from them can be made public or disclosed more broadly. For A, child traffic violators, 15.K2, A, on page 116, records related to minor traffic offenses are often more readily accessible than other juvenile delinquency records. The lower severity of the offense leads to less strict confidentiality. Then, for B, felony arrests and adult system transfers, 15.K2, B, on page 116, if a juvenile is arrested for a felony, or if their case is transferred from the juvenile justice system to the adult criminal justice system, certain records may become public. This reflects the increased seriousness of the offense. C, mandatory notification to schools, 15.K2, C, on page 117, requires that schools be notified when students are involved in certain criminal incidents. This information is confidential at the school, but the notification itself is an exception to broad confidentiality. D, criminal history information relating to juveniles, 15.K2D, on page 117, clarifies that while juvenile criminal history is usually sealed or confidential, there might be specific instances where it becomes accessible, particularly if they commit new offenses or if there are public safety concerns. Finally, E, victim access, 15.K2E, on page 117, allows victims of juvenile crimes to access certain information related to the juvenile's case, balancing the juvenile's privacy with the victim's rights. Segment 2, C, what records are covered? Law enforcement records, motor vehicle records, pages 117 to 119. Moving to page 117, we transition to L, motor vehicle records, 15.L. Law enforcement agencies often collect and maintain various types of motor vehicle-related information. First, 1. Automated license plate, Plate recognition system records, 15.L1. On page 117, these systems, often called ALPRS, capture images of license plates and their precise location, essentially creating a record of where vehicles have been. These records are considered confidential and exempt from public disclosure. This protects the privacy of individuals and prevents the misuse of location tracking data unless the information is directly relevant to a specific criminal investigation. Next, 2. Crash reports, 15.1.2, on page 118. These are reports detailing traffic accidents. While basic information about a crash like date, time, location, parties involved, and general description is typically public, there's often a limited period, usually 60 days from the date the report is filed, during which these reports are confidential and only accessible to parties directly involved in the crash, their attorneys, or insurance companies. This confidentiality is intended to protect the privacy of those involved and the integrity of any potential legal claims. After that 60-day period, they generally become public. Then, 3, traffic citations, 15.L3, on page 118. These are tickets issued for traffic violations. Generally, traffic citations, once issued and filed, are considered public records. This is because they document an official enforcement action related to public safety. Finally, for this segment, 4. Department of Highway Safety and Motor Vehicles motor vehicle records, 15.1.4, on page 119. These are the extensive records maintained by the state's Department of Highway Safety and Motor Vehicles, or DHSMV, including driver's license information, vehicle registration, and ownership details. While some basic information might be public, much of this data is confidential under federal law, like the Driver's Privacy Protection Act and Florida statutes to protect personal privacy from misuse, such as stalking or commercial solicitation. Access is typically restricted to law enforcement, government agencies, or specific authorized purposes. Segment 3. C. What records are covered? Law enforcement records, pawnbroker, polygraph, prison and security, pages 119 to 120. Moving to page 119, we look at several other types of law enforcement records. First, membership pawnbroker records, 15M, on page 119. Law enforcement agencies often collect records from pawnbrokers which detail items pawned or sold and the identities of the individuals involved. These records can be crucial for investigating thefts. Information identifying individuals who pawn or sell items and the details of those transactions are typically confidential and exempt from public records to protect the privacy of individuals and the integrity of ongoing investigations into stolen property. Next number, polygraph records, 15.N, on page 119. Polygraph examinations, often known as lie detector tests, are sometimes used in law enforcement investigations or for employment screening. The records from these examinations, including the questions asked, responses, and results, are generally considered confidential and exempt from public disclosure. This protects the privacy of the individuals who undergo the tests and prevents the misuse of often unreliable results. Also on page 119, we cover O-Prison and inmate records, 15O. These are records related to individuals incarcerated in state prisons or county jails. While some basic information about inmates, like their name, charges, and incarceration status, might be public, much of their personal information, medical records, mental health records, and details that could jeopardize security or rehabilitation efforts are confidential and exempt. This protects inmate privacy, facility security, and rehabilitative goals. Moving to page 120, we find P, resource inventories and emergency response plans, 15 P. These are records that detail a law enforcement agency's tactical resources, personnel deployments, or strategies for responding to emergencies. Such records are typically confidential and exempt from public disclosure. The reason is straightforward. Making this information public could severely compromise public safety by revealing vulnerabilities, allowing criminals or hostile actors to anticipate and circumvent law enforcement responses. This exemption is crucial for operational security. Finally, for this segment on page 120, we have Q, surveillance techniques, procedures, or personnel, 15Q. This refers to records that reveal how law enforcement conducts surveillance, what technologies or methods they use, or the identities of personnel involved in sensitive operations. These records are almost universally confidential and exempt. Disclosing this information would immediately compromise the effectiveness of investigative techniques, endanger officers, and impede law enforcement's ability to monitor or disrupt criminal activity. It's a vital exemption for maintaining operational effectiveness. Segment 4, C, what records are covered? Law enforcement. Records, undercover personnel and victim information, pages 121 to 127. Moving to page 121, we continue with law enforcement records. First, R, undercover personnel, 15.R. Information that could reveal the identity of law enforcement officers who work undercover, e.g., in narcotics, organized crime, or vice operations, is always confidential and exempt. The safety of these officers depends entirely on their identities remaining secret. Public disclosure would not only endanger them, but also immediately destroy their effectiveness in infiltrating criminal organizations. This is one of the strongest exemptions in public records law. Next, on page 121, we come to S, victim information, 15.7. This is a very sensitive and complex area, heavily impacted by Marsy's Law, which we discussed in episode 11, and by various statutory exemptions designed to protect crime victims. 1. Marsy's Law, 15-1, on page 121, as a reminder from episode 11, Marsy's Law, Florida Constitution, Article 1, Section 16, subsection B, provides crime victims with a set of constitutional rights, including the right to privacy and protection from harassment. While the Florida Supreme Court in City of Tallahassee versus Florida Police Benevolent Association, Incorporated, 377 Southern 3rd, 331 Florida, 2023, clarified that Marsy's Law does not grant a categorical right for a victim's name to be withheld. It does provide significant protection for information that could be used to locate or harass a victim. This means that details like home addresses, phone numbers, and other locating information are often confidential. Then we look at 2, statutory exemptions relating to victim information, 15.72, starting on page 122. These are specific laws that further define what victim information is confidential beyond the broad constitutional protection of Marsy's Law. A. Amount of stolen property, 15.G2A, on page 122. While the fact that property was stolen might be public, specific details about the amount or value of stolen property might be exempt, especially if it could lead to further victimization or reveal sensitive financial details. B. Commercial solicitation of victims, 15.S2.B on page 122. This exemption prevents the release of victim information for commercial purposes, protecting victims from unwanted solicitations. Like C, documents which are received by an agency regarding victims, 15.S2I on page 122. This covers a broad range of materials received by agencies that pertain to victims and often makes them confidential if they contain sensitive identifying information. Where D, home or employment address, telephone number, assets, 15.72D, on page 122. For victims of certain crimes, especially domestic violence, sexual battery, or stalking, their home and employment addresses, phone numbers, and details about their assets are typically confidential and exempt to protect their safety and prevent further harassment. Moving to page 123, we find E, information identifying or depicting victims of sex offenses and of child abuse, 15.S2.E. This is an extremely strong area of confidentiality. Law enforcement and prosecution records, 15.S2E1. On page 123, that identify or depict victims of sex offenses or child abuse are generally confidential and exempt. This protects the identity and privacy of these vulnerable victims. Court records, 15.S2E2. On page 125, relating to victims of sex offenses or child abuse are also highly protected. While some court proceedings are public, identifying details of these victims are typically sealed or redacted. 3. Department of Children and Families abuse records, 15.S.2.E.3. On page 125, as we discussed in episode 11, are also confidential in this context. On page 125, the manual also covers F, homicide victims and witnesses, and persons whose manner of death was suicide, 15.2.2. 1. Photographs and video or audio recordings of killing of law enforcement officer, killing of a minor, the killing of a victim of mass violence, or the suicide of a person, 15.S2F1 *** on page 125, are explicitly confidential to protect the dignity of the deceased and their families from graphic public display. 2. Address of victim of an incident of mass violence, 15.722. On page 126 is confidential to protect the privacy and safety of families after such a tragedy. 3. Autopsy report of death of minor due to domestic violence, 15.S.2.F.3 on page 126 is confidential. 4. Autopsy report of suicide of a person, 15.72, 2, F, 4, asterisk, asterisk, disc, comma, asterisk, 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 Sarsk, Istrisk, Sarsk, 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 Asterisk, 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 Asterisk. 5. Homicide witness 15.S2F5. Wimoshgale on page 126 may have their identity protected if their safety is at risk. Finally, on page 126 we have G, human trafficking victims, 15.S2G. Information that identifies victims of human trafficking is also typically confidential and exempt to protect their safety and facilitate their recovery. And to round out this section, on page 127, we have H, relocated victim or witness information, 15.2H. If a victim or witness has been relocated for their safety, that information is, of course, confidential to protect them. This concludes our incredibly detailed exploration of various categories of law enforcement records under C. What records are covered? Taking us through page 127 of your manual. Thanks for listening. In our next episode, episode 16, we'll continue exploring C, what records are covered, by shifting to litigation records, personal records not made or received in the course of official business, and the beginning of personnel records, taking us through page 139 of your manual. Until next time, remember, the truth dies in the dark. So let's leave the light on.